So we have some important news coming out of the next big Supreme Court case, which is a challenge to the ATF's overreach and some of their rules against unfinished frames and receivers. So let's break down what is now happening. Now, as I mentioned in the intro, in this video, I have some important news coming out of the next big firearms case, which is currently in front of the Supreme Court. The Supreme Court recently granted review to the ATF's frames and receivers case called Vanderstock versus Garland. The case is now set to be heard and decided by the Supreme Court during the Supreme Court's next term. And even more important, this case has the benefit of the Supreme Court recently issuing a new decision against the ATF's bump stock rule, and that was a 6-3 decision in the Cargill case. The Supreme Court has now set oral arguments to take place in the Vanderstock case on October 8th, and the ATF just submitted their final arguments to the Supreme Court on why the Supreme Court should in fact reverse what the Fifth Circuit said. And it's very interesting because the ATF is making a bunch of Hail Mary arguments, and also interestingly, they finally address how the Cargill case will impact what's going on in Vanderstock. Now, to understand what's at stake in this case and why the Supreme Court's hands were forced to have to take review of this case, we need to talk about what happened prior in this lawsuit. So originally in this case, the original plaintiffs, FBC and Tactical Machining, sought preliminary injunctions to halt the enforcement of the ATF's rule against unfinished frames and receivers. On review, Judge O'Connor granted a limited preliminary injunction against the ATF, which prevented the ATF from enforcing the rule against Tactical Machining and its customers. Looking at the ATF's rule against frames and receivers, Judge O'Connor did find that under the plain text of the statute, the ATF had engaged in overreach and that these parts and kits are actually not firearms like the ATF claims. Now, after that, there were a bunch of other companies who joined as new plaintiffs, companies like Blackhawk Manufacturing Group, which is 80% Arms, and some others. They sought to intervene and they got the same type of protections that Tactical Machining got for their company and their customers. Now, after the preliminary injunction stage, the plaintiffs sought to win the entire case by asking for a motion for summary judgment. And in response, Judge O'Connor did grant that motion for summary judgment, striking down the rule in its entirety, and he ultimately vacated the frames and receivers rule entirely nationwide. Well, of course, the ATF could not have their entire rule vacated, so then they appealed that summary judgment up to the Fifth Circuit. The ATF then sought a stay from the Supreme Court so that they could still enforce the rule while the summary judgment appeal was going on. However, both Judge O'Connor and the Fifth Circuit motions panel denied that stay request, and that led the ATF for the first time to go to the Supreme Court on an interlocutory emergency basis, and they wanted the Supreme Court to step in early and essentially put a block on that lower court decision. And the Supreme Court on review did in fact issue an emergency stay, and essentially it prevented the nationwide vacatur of that rule, and that was a 5-4 order by the Supreme Court. Now, while all that was also happening and after that happened, the plaintiffs here decided to go back down to the lower court judge, Judge O'Connor, to seek an emergency motion for a new preliminary injunction. What they wanted was for Judge O'Connor to put back in place the limited preliminary injunctions, which would only protect the companies and the customers. Essentially, they wanted the old status quo to be put back in place despite what the Supreme Court just said. And on review, Judge O'Connor agreed and granted that limited preliminary injunction. But of course, once again, the ATF did not like that happened, so they went crying up to the Fifth Circuit, arguing that Judge O'Connor was directly defying the Supreme Court's 5-4 order, that the plaintiffs here were trying to circumvent that order, and the Fifth Circuit disagreed, and that for the second time led the ATF filing for emergency review in the Supreme Court. They wanted review of what they claimed was the plaintiffs and the lower courts circumventing that order. And on review for the second time, the Supreme Court sided with the ATF and struck down even that limited preliminary injunction. So the Supreme Court prevented any positive relief in this case while the summary judgment was being appealed in the Fifth Circuit. The Fifth Circuit recently did decide on the merits of this case, and in their decision, the panel partially upheld what the lower court decision said, striking down the ATF rule nationwide. However, the Fifth Circuit did say that that nationwide vacatur by Judge O'Connor was beyond his authority, that he went a little bit too far. And so essentially the Fifth Circuit did find that the ATF's rule was invalid, that the ATF engaged in overreach, but they just found that the form of relief granted by the lower court judge was a little bit too expansive, too broad, and so they sent it back down to Judge O'Connor for him to issue a new decision, maybe more limited in scope. After that Fifth Circuit decision on the summary judgment, the ATF really didn't have a ton of options, so they decided to roll the dice and go up directly to the Supreme Court for a review of that final merits decision from the Fifth Circuit. And now the Supreme Court has granted review also to this Vanderstock Stock case, a review of the unfinished frames and receivers rule. In their petition, the ATF really made the same fear-based ghost gun arguments that we've heard a lot already in this case. They simply argue that the regulation is important to essentially track firearm sales and to avoid criminals ultimately skirting the laws and getting possession of what are untraceable firearms in the ATF's eyes. The ATF is also still holding on to the argument that the potential ease of completing the unfinished frames and receivers makes the entire parts kits fall within the statutory text and language. So they're still making the arguments that they can regulate even parts kits as actual firearms. Now, you may be asking yourself, okay, also with this petition and with the Supreme Court's recent decision in Cargill, how is the ATF addressing that? Well, as we've talked about in prior videos, on the ATF's first petition, they really didn't address Cargill at all. In some of their original briefs, they did not address Cargill at all. I think it was only mentioned one time, but the plaintiffs here have used Cargill as additional support for why the Supreme Court should side with them. And because of that, the ATF essentially now had to address that argument. And in their most recent brief, in their final brief, the ATF does address how Cargill impacts this case, but again, they only reference it 4 times in a very short paragraph. The ATF takes the position that the Cargill analysis did not apply to this issue at all because they claim that 80%ers are geared towards circumventing the GCA's language. The Supreme Court found in the Cargill case that bump stocks were not geared towards circumventing the GCA and the NFA. However, here the ATF claims that Cargill wouldn't apply and that analysis wouldn't apply because they believe that 80%ers are geared towards circumventing the language. The ATF also claims that their position that 80%ers are regulated as firearms, that has been a consistent perspective from the ATF, that they've always regulated these items, and so there's not a drastic change in position like they claim was present in the Cargill case. It's interesting that the ATF is now trying to claim that their position on 80%ers and parts kits and unfinished frames and receivers, that has always been their position, that they've always claimed that these types of items are in fact firearms. However, we know that that fact is not true. The ATF has not always treated these items as regulated. In fact, we have multiple ATF guidance letters and multiple situations where the ATF has taken a different position. And now suddenly with the new rule, they changed their perspective so that they could regulate all these items. The plaintiffs stated in their brief on this very issue that the argument that the ATF's position has remained consistent also is contradicted by ATF's repeated statements that the rule was necessary to address the urgent public safety and law enforcement crisis posed by the exponential rise of untraceable firearms, and by ATF's express refusal to grandfather in its prior classifications of any partially complete, disassembled, or non-functional frames or receivers that ATF did not classify as firearms frames or receivers as defined prior to the rule. So what the plaintiffs are pointing out in their briefs and what the ATF is now trying to address in their final brief is the wishy-washy back and forth position that the ATF has taken on this very issue. And then also in the final rule, the ATF stated that they were going to eliminate and not grandfather in any prior guidance on these types of items. The ATF did that because they knew if they grandfathered in prior guidance, it would contradict what the new rule statements were about these types of items being actual firearms. So the ATF is trying desperately to save their frames and receivers rule, but after the Cargill decision, I think the writing is on the wall for the ATF. The ATF knows that. They've lost multiple cases in the Fifth Circuit, at the Fifth Circuit level, at the en banc level, even in some district courts, they've lost a ton of cases. So the ATF knows that this is an uphill battle. Now, like I mentioned, the oral arguments are set in front of the Supreme Court. Those are going to take place on the 8th. That will be live. We can listen to those live. So maybe we'll do that also. If you're interested, let me know in the comment section. But we're all going to be waiting anxiously to hear those arguments because it's going to be interesting and probably very enjoyable to hear the ATF squirm about these types of items and how parts and kits that are unfinished and not operable are actually firearms. So if anything else changes, if we get any more information, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.